Hey everyone, welcome back to the channel. In today's video, we follow a person known for his sovereign citizen beliefs, who has recently been charged with a DUI and decided to represent himself in a bench trial. As we go through the story, we start with his first 2 court appearances, then move into his 3rd appearance, and finally examine key moments from the trial itself. What he expects and what actually happens are very different, and the process becomes more complicated than he imagined. Let's break down each stage and see how the situation unfolds in court. The video also highlights how self-representation in court can lead to unexpected challenges, especially when legal procedures are not fully understood, making each hearing more intense and unpredictable for everyone involved.
I'm here to make a special appearance.
Well, what's your name, sir? Can you tell me your name?
Don Lyons.
Okay, we're on 2508, CM 2346, State v. Don Lyons, who is here today via Zoom, states again present. Let's see, advised at your initial hearing, you wanted to proceed pro se, without an attorney. Is that still your intent today, sir?
Say it again.
Is it still your intent to go forward without an attorney?
Yes, sir.
Okay, so we have 2 options today. You can either ask for some more time to either put together a defense or hire counsel or talk to the state about any potential resolution, or we can simply set this matter for a bench trial. Which of those 2 options would you like today, sir?
I would need to request a continuance to work on my defense.
Any objection? I say no objection. Right. Looking to age the case, that's fine. So I'm going to reset this for December 22nd at 8:30. So Mr. Lyons, we'll see you back here on that date and time.
Say it again. You said
December 22nd at 8:30.
December 22nd. All right, thank you.
Yep. All right, so we're on 2508 CM 2346, State v. Don Lyons, who's here today in person. State is also present. So we're here. All right, so the state has filed 1 additional charge. It's for count 3, operating vehicle with an ACE of 0.15 or more. The state alleges that on about July 21st of this year in Montgomery County, state of Indiana, you did operate a vehicle with an alcohol concentration equivalent to at least 1,500ths of a gram of alcohol per 100 milliliters of your blood. Class A misdemeanor carries with it a penalty from 0 to 365 days, Montgomery County Jail, and a fine of up to $5,000. Do you understand the allegations against you and the possible penalties?
I'm here to make a special appearance, and I had sent a motion.
Yeah, so that was filed this morning.
A motion to get this dismissed.
Okay, since that was just filed today, I don't even know if the state's received a copy of that. I'm not going to set that for hearing today, but what we'll do is set that. We'll set this for another pretrial conference, and that we can address that motion at that point. We'll do that. Set that. Say January 26th at 9:30.
What date is that?
January 26th.
What's that date? Well, no, I'm sorry.
Okay, we're gonna do the 28th.
Yeah, 28th.
Okay, we'll say January 28th at 10.
Here we see the same familiar approach being used again, questioning the court's authority, requesting special appearances, and raising arguments that do not carry legal effect in an actual courtroom. These points are repeated as part of his defense strategy, even though they are not accepted by the judge. Each time they are brought up, the court responds by moving the process forward rather than engaging with them in detail. After these exchanges, the focus of the case shifts forward. With those earlier arguments addressed, we now move on to his 3rd court appearance, where the situation continues to develop and the proceedings become more serious and closely examined by the court as the trial progresses. Each step adds more complexity as the hearing continues overall in court.
There we go. This is 2508 CM 2346, State v. Don Lyons, who's here today via Zoom. State's here in the courtroom. We're set for a pretrial conference. Lyons, the first question is, you've been appearing pro se. Is that still your intent, or do you intend on hiring counsel, or do you want me to consider appointing an attorney for you?
No.
Okay. So I'm going to advise you, just in proceeding pro se, you are going to be held to the same standard as if you were an attorney. You're going to be expected to understand the rules of trial procedure, rules of evidence, rules of criminal procedure. Do you understand all that if you go forward without an attorney?
Yes.
Okay, so I think
I had wrote an affidavit. No, I'm still waiting for a response.
okay, and I see that affidavit, and I think we received that the date of our last hearing. It doesn't look
Correct.
to doesn't make any specific requests. It's a request for dismissal of charges, and this does not comply with Criminal Rule 2.7. It's also not an appropriate motion to suppress.
I have to object to that.
Understood. So what I'm going to do is I'm just going to set this matter for a bench trial. Set that April 1st at 1:30. So that's going to be the court's order for today. This will be set for a bench trial April 1st at 1:30. And all parties are going to be ordered to be here in person on that date.
Nothing significant takes place in that hearing. Only another example of his limited understanding of how courtroom procedure works. Things do not improve as the case moves forward. Entering the bench trial, he makes very little attempt to properly question or respond to the witnesses presented against him. For clarity, we'll skip the routine questioning of the arresting officer and focus instead on the cross-examinations. Those moments become a clear illustration of common mistakes made when someone chooses to represent themselves without legal preparation or strategy in court. The focus shifts entirely to how the proceedings unfold in real time, highlighting the contrast between expectations and courtroom reality. Overall, the trial moves forward step by step, showing how each decision affects the outcome.
This is 2508 CM 2346, State v. Don Lyons. It's here today in person. State's President and Deputy Prosecutor Tyler Trulock. We're set today for a bench trial on counts 2 and 3. Count 1 was previously dismissed. Michelle, I just say you wanted to note something before we begin?
Yes, I'm here for make a special appearance.
Okay, and what do you mean by that?
Like I know I'm here to represent myself and challenge the jurisdiction.
What's your request to challenge the jurisdiction?
The OWI
Okay.
that was said that they had a warrant for to take my body fluids, but I don't.
The hearing opens with the defendant stating he is entering a special appearance, as the case State versus Don Lyons is called for a bench trial on counts 2 and 3, while count 1 has already been dismissed. Deputy Prosecutor Tyler Trulock is present, and the judge asks the defendant to explain his position. The defendant says he will represent himself and is appearing to contest the court's jurisdiction. When pressed for details, he refers to an OWI charge and claims officers said they had a warrant for his arrest, but he has never been shown one. He uses this claim as the reason for questioning the court's authority.
Your evidentiary has come and gone. Today we're set for a trial on the facts that matter. So if you have issues with the evidence being introduced as it's being introduced, you can make appropriate objections. We're going to go forward today. State, you ready to proceed?
Yes, sir.
Go ahead.
Your Honor, the state calls Trooper Devin Walsh. Any questions, Mr. Lyons?
Yes. You, what side of the car you was on when you first said you had smelled? When you had first asked, was y'all smoking any marijuana in the car?
Passenger side.
And then right after that, you had said you had smelled alcohol, right?
Yes.
It was on the passenger side?
So alcohol on the passenger side and on the trucker side.
But she was on the passenger side first, right, when you said it, correct?
Yeah.
Alright. So when you came to the driver's side, and I got out the car and I told you I refuse to take the test. We went to the hospital. How can I say? When did you present me the warrant?
I read you the warrant right before we drew your blood. Like I'm supposed to.
This is on file.
It's on camera.
Is it on file though?
They have my body camera. They have it all.
On file?
So you have to ask questions about this.
So you don't know if it's on file or not?
They have all my body camera, dash camera,
You don't know.
all that. I sent it to them, so I would assume so.
You said the warrant was signed around 6/21.
Well, it was around 6/21, so I've read you the warrant that I did. So I did read it to you right before the blood draw happened.
You have any proof of the audio?
Audio, it's on my body camera. It's on all the time.
I can't see it. And I see it. But I really don't recall. And if there was a warrant, you know what I'm saying?
It was
Go about it like that. But I don't recall no more.
Well, I'm sure to say that.
Like,
You have any questions?
I was on. I do, but not right. Not at the moment.
Anything up?
In response, the judge questions the defendant's statement and suggests that his recollection of the incident may not be fully accurate. He asks whether it is possible that the warrant was not clearly remembered because the defendant may have been under the influence at the time, leaving him unable to fully understand or recall what was happening during the encounter. The court further explains that impaired awareness can significantly affect memory of events during an arrest situation and emphasizes the need for clear and consistent facts before proceeding with any argument regarding jurisdiction or the validity of the stop. It also instructs that the discussion should remain focused on verified facts presented in court.
Mr. Lyons, do you have any questions for this witness?
Yes. That was a while ago, but you know around the time that they took my blood?
I don't remember.
That's all I had.
Anything else that say?
No, you're.
You can step down, ma'am.
Okay.
Mr. Newtown, is there anything else you'd like the court to know at this point?
Do not believe so.
No. Thank you.
Do you have any questions, Mr. Lyons?
No, sir.
This is the only witness the defendant seriously attempts to question. But even then, his attention stays limited to whether a warrant was actually read to him while he was intoxicated and receiving treatment in the hospital. He does not explore procedural details or raise broader issues like probable cause, which are typically key areas in cross-examination by a trained defense attorney. After this, the testimony of the hospital nurse and the lab technician who handled and analyzed his blood samples is presented. These parts of the trial are summarized quickly, focusing mainly on the defendant's cross-examination, which does not develop into any meaningful challenge or detailed questioning, and remains largely ineffective overall in substance and direction throughout the proceedings.
I didn't give you the motion of discovery. I was thinking I was gonna send it to me. I didn't know I had to file for it. That's my ignorance. I don't have no evidence. No, sir.
So today's trial, the state needed to prove, carry their burden, need to prove beyond a reasonable doubt on count 2 that Mr. Lyons had operated a vehicle while intoxicated, and on count 3 that it operated with an ACE of 0.15 or above. State has proven that he was operating a vehicle, and through the expert testimony has proven both counts 2 and 3 beyond a reasonable doubt. We can proceed to sentencing. Mr. Lyons, is there anything you'd like me to consider on sentencing?
I mean, my granny got to get back home today, and I really don't remember or recall them showing me that warrant in that hospital. I kind of remember that night for the most part, but I was hoping to see the audio or see the documents of timing of the warrant. And but they were presented. I think that'd be nice.
Any on sensing state?
Just a few questions, Your Honor. Mr. Lyons, are you currently employed?
Yes, sir.
Where do you work?
Work at Penn Station right now, Earth Park.
Okay. Is that a full-time job?
Yes, sir. Now it is. I was working 2 at first.
Okay. And where do you live?
Well,
Okay. Louisville, Kentucky.
yes, sir.
Mr. Lyons, do you have any criminal history of any kind?
Yeah, look right. Like the criminal history.
Yes.
I got a look right. Mainly tried. Yeah.
So what have you been convicted of criminally?
That's some marijuana. Some marijuana. Pretty much.
Is it possession of marijuana?
Yeah, that's
Okay. Is that the only thing you've been convicted of?
I can think of right now.
Okay. No previous operating while intoxicated convictions, anything like
No,
that?
it's my first time. The first time.
Thank you.
Following the judge's remarks, the court confirms that the defendant has been found guilty based on the available evidence and the expert testimony that was not challenged or disputed during the trial. With no effective rebuttal presented, the prosecution's case stands as proven in the court's view. Attention then turns to the final stage of the proceedings, where the judge is about to announce the sentence. The atmosphere in the courtroom shifts as everyone waits to hear what penalty will be imposed, marking the conclusion of the trial and the next step in the legal process. This moment signals the transition from verdict to sentencing, bringing the proceedings to their final and most decisive point in court.
State?
No.
What's the state's request on sentence today?
Your Honor, state doesn't have any reason to doubt what Mr. Lyons said about this being his first operating while intoxicated conviction. The state is concerned by the fact that Mr. Lyons was operating a vehicle with an alcohol concentration above 0.15. However, it does not appear that Mr. Lyons has many, if any, ties to this community. So the state's first inclination as to sentencing would be to ask for just a short executed sentence for him to be done with this case. If the court's not inclined to do that, the state would just request a 365-day sentence suspended to probation, as well as a reasonable fine and license suspension. Thank you, Your Honor.
So, yeah, those are my things to consider. Understandably, if I would put you on probation, it'd be a misdemeanor probation that is difficult to transfer across state lines, and that's going to be very difficult to have done with you living in Louisville, Kentucky. So what the court's going to do today, given your lack of criminal history, is I'm going to sentence you to 10 days in the Montgomery County Jail. That's 5 actual. So you've got credit for 1 actual day already when you were first arrested. So you're going to have 4 days remaining to do. So you're going to be taken into custody, placed in the custody of Montgomery County Jail today. You're going to be released 4 days from today. And there's going to be court costs of $189.50. And I'm not going to impose any additional fine. There's a $200 alcohol countermeasure fee. There's also going to be a 90-day license suspension that's going to go into effect tonight at midnight.
That's suspension for the state of Indiana.
Yes.
All right.
So I'm not sure how that transfers to Kentucky. That's going to be the order for today. So you're going to be remanded in custody.
All right. So what about man, I don't know, my granny though. Like she can't really see like that. Like I gotta help her get her.
Well, sir, you've known for quite some time that you were scheduled for trial today.
Yeah.
And so
Well, I was
plans you've made
Right.
are on you. So that's going to be the order for today.
I'll get out go there.
And I will notify you have 30 days to file a notice of appeal if you want to appeal this decision.
It seems like the grandmother will need to arrange a different way to get home, as the outcome changes the situation for everyone involved. This also reflects how important it is to stay responsible when others are relying on you, including respecting legal processes rather than trying unconventional courtroom arguments. With that, the video comes to an end. It's been some time since the last case, and although this one was relatively brief, there are many more similar situations coming soon. If you enjoyed the content, you can like it, and if not, you can dislike it. Either way, you're welcome to leave a comment and subscribe with notifications turned on so you don't miss the next updates.